Number 30. Store your phone in the center console. During traffic stops, placing your phone in your center console before police approach removes it from plain view, creating a Fourth Amendment barrier that requires probable cause for search. This tactical positioning emerged from the 2021 U.S. versus Payne case, where visible phone placement gave officers justification to demand access. The advantage lies in forcing law enforcement to articulate specific criminal suspicion rather than relying on opportunity. Critics argue this appears evasive and might heighten officer suspicion during routine stops. The positioning works because courts have consistently ruled that closed compartments receive greater privacy protections than items in plain view on seats or dashboards. Officers conducting traffic stops can observe everything visible through windows without Fourth Amendment implications, but opening closed spaces requires either consent, probable cause, or a warrant. The verdict: it's a practical privacy measure that costs nothing and creates legal hurdles for warrantless searches, though it works best when combined with other protective strategies and requires remembering to secure your phone before blue lights appear in your rearview mirror. Number 29. Disable biometrics before risky encounters. Switching off fingerprint and facial recognition temporarily when anticipating police interaction prevents forced biometric unlocking that courts classify as non-testimonial. Unlike passcodes protected by the Fifth Amendment, biometric features are treated like physical characteristics that can be compelled without warrant. Reddit communities emphasize this as essential preparation during protests or high-risk situations where police presence is expected. The downside involves remembering to disable features in stressful moments and potentially fumbling with settings when time matters most. Some users report making this a routine practice before any driving, treating it like fastening a seatbelt as automatic precaution. The temporary nature means you can re-enable convenience features once you're safely home or away from potential law enforcement encounters. The verdict: preemptive disabling offers stronger protection than hoping officers won't physically force your thumb onto the scanner, making it worthwhile despite the inconvenience of temporarily losing quick access features you've grown accustomed to using dozens of times daily. Number 28. Understand the difference between testimonial and non-testimonial acts. Knowing that revealing the contents of your mind receives Fifth Amendment protection, while physical characteristics don't, explains why passcodes shield you but fingerprints don't. The Supreme Court carved this distinction through cases involving blood draws, lineups, and handwriting samples, establishing that incriminating evidence lacking mental content can be compelled. This framework directly impacts phone security, since typing a password requires transmitting knowledge from your brain while pressing your thumb conveys nothing cognitive according to judicial reasoning. Legal advice forms stress this as foundational knowledge for asserting rights effectively. The limitation is that this distinction feels arbitrary when biometric unlocking reveals your entire digital life just as thoroughly as passcode entry. The distinction originated in pre-digital cases where physical evidence like fingerprints truly differed from verbal testimony. But modern technology has blurred these lines in ways courts struggle to address consistently. The verdict: understanding this legal architecture empowers informed decisions about device security, even if the underlying logic seems inconsistent with modern realities of comprehensive digital surveillance and the wealth of personal information accessible through biometric access. Number 27. Know that silence alone doesn't invoke Fifth Amendment protection. Simply remaining quiet during police questioning fails to trigger constitutional safeguards according to Supreme Court precedent requiring explicit invocation. Officers can interpret silence as suspicious behavior or continue questioning indefinitely until you verbally claim your right. Reddit threads document cases where suspects believed staying silent protected them only to have statements used against them because they never formally invoked. The challenge involves remembering precise phrasing under pressure when most people instinctively think silence speaks for itself. This counterintuitive requirement stems from Salinas versus Texas, where the Supreme Court ruled that pre-arrest silence can be used against defendants who don't explicitly invoke. The decision means your natural instinct to stay quiet provides zero protection unless accompanied by magic constitutional words. The verdict: this counterintuitive requirement makes verbal invocation essential, transforming what should be automatic protection into a procedural trap for the uninformed who reasonably assume remaining silent exercises the right to remain silent without needing to announce it verbally. Number 26. Recognize that police can't lie about detention status. When officers falsely claim you're free to leave while treating the encounter as a detention, they create Fourth Amendment violations that can suppress evidence. Courts evaluate detention based on whether a reasonable person would feel free to leave, not officer statements, making deceptive answers about detention status legally problematic. Online commentaries note this as a reason to ask directly, since evasive responses often signal illegal stops. The complication arises when officers use ambiguous language like "I'd prefer if you stayed" that blurs consensual versus compelled encounters. Some jurisdictions apply more stringent standards than others when evaluating whether circumstances created reasonable belief that departure wasn't permitted. The objective reasonable person standard means your subjective fear doesn't control the analysis, but rather what hypothetical reasonable people would perceive about their freedom. The verdict asking forces clarity that protects both your immediate freedom and potential legal challenges, though sophisticated officers know how to dance around direct answers using carefully trained language that maintains plausible deniability about whether detention occurred. Number 25. Learn your state's badge number requirements. Some jurisdictions legally mandate officers provide identification when requested, while others treat it as courtesy, making local law knowledge crucial for accountability. New Jersey and UK policing explicitly require badge disclosure, while other areas leave it discretionary. The practice serves multiple functions, including confirming legitimacy against impersonators and documenting officers for complaints. Sovereign citizen movements poisoned this reasonable request by turning it into confrontational theater, causing some officers to view the question with suspicion. Many departments now have policies encouraging identification provision to maintain public trust even where not legally required. Body camera footage has made documentation easier but doesn't eliminate the value of knowing exactly which officer you're dealing with during encounters. The verdict, knowing whether your location mandates compliance determines whether this request carries legal weight or merely establishes a paper trail, making it situationally valuable rather than universally powerful, but still worth asking to create accountability. Number 24. Understand probable cause requirements for console searches. Officers need articulable criminal suspicion beyond mere curiosity to search closed compartments like center consoles, creating higher thresholds than plain view observations. This protection stems from Fourth Amendment requirements that searches be reasonable and justified by specific circumstances. Traffic stop case law establishes that minor violations don't automatically authorize full vehicle searches without additional indicators. The gray area involves officer claims of smelling marijuana or observing furtive movements that courts often accept as probable cause. Different circuits apply varying standards for what constitutes sufficient probable cause, creating geographic inconsistency and protections. The automobile exception to warrant requirements already reduces privacy expectations in vehicles, but closed containers maintain some constitutional protection even within cars. The verdict: console storage leverages existing legal protections effectively, though police experience in manufacturing justifications means it's not foolproof against determined searches by officers trained in articulating legally acceptable reasons. Number 23. Know the difference between detention and arrest. Detention allows temporary stops for investigation based on reasonable suspicion, while arrest requires probable cause and leads to booking, creating different rights at each stage. During detention, officers can conduct pat-downs for weapons, but not full searches unless they develop probable cause. Understanding this distinction helps evaluate whether police are exceeding their authority during encounters. The practical difficulty involves recognizing transitions between stages when officers don't announce them clearly. Detention can evolve into arrest as circumstances develop, and the line between investigative stop and custodial arrest often becomes clear only in retrospect. Courts look at factors like use of handcuffs, placing suspects in police vehicles, and duration of detention when determining whether arrest occurred. The verdict: this knowledge enables real-time assessment of whether your rights are being violated, though most civilians struggle to apply legal standards during high-pressure encounters when adrenaline clouds. Judgment and legal distinctions feel academic. Number 22. Recognize consent. Search tactics. Police frequently request searches by making them sound mandatory through phrasing and tone, even when they legally need permission, exploiting most people's deference to authority. Consent searches bypass Fourth Amendment warrant requirements entirely, making them law enforcement's preferred method. Online discussions emphasize that officers trained in these psychological techniques won't typically accept initial refusals gracefully. The innocent person paradox suggests complying seems reasonable if you have nothing to hide, but creates unnecessary risk. Training manuals teach officers specific language patterns that maximize consent rates while maintaining technical voluntariness for court review. The power dynamics inherent in police encounters make truly voluntary consent questionable, even when suspects believe they're choosing freely. The verdict: recognizing these tactics as voluntary requests rather than commands fundamentally changes encounters, though social pressure makes refusal psychologically difficult regardless of legal rights, especially when officers imply that refusal suggests guilt, establishing that invasive bodily searches need judicial authorization. This precedent makes Judge Tillman's reasoning in the Payne case puzzling, since he compared forced biometric unlocking to warranted blood draws while claiming no warrant needed. The contradiction highlights inconsistent application of Fourth Amendment protections across different search types. Medical privacy advocates view blood draw protections as partial victories in the broader fight against suspicionless searches. The ruling in Birchfield versus North Dakota carved out narrow exceptions for alcohol testing under implied consent laws, but generally requires warrants. The decision recognized that blood draws constitute significant bodily intrusions, requiring heightened constitutional scrutiny. The verdict: this requirement demonstrates courts can impose meaningful limits on police intrusion, even as other rulings like Payne weaken privacy protections elsewhere, creating an inconsistent patchwork of digital versus physical privacy rights. Number 20. Learn about implied consent traps. Ambiguous responses or cooperative behavior can be interpreted as consenting to searches even without explicit verbal agreement, creating legal vulnerabilities. Courts sometimes find implied consent in circumstances where suspects didn't clearly object, making explicit refusal crucial. Reddit legal communities warn that handing over your phone while asking if they need a warrant might constitute implied consent depending on jurisdiction. The doctrine particularly affects traffic stops where license production and license plate scanning already involve consent to certain intrusions. Some courts have found consent implied through body language or failure to object when searches began. The standard asks whether a reasonable person would have understood the suspect consented based on the totality of circumstances. The verdict: avoiding these traps requires over-communicating non-consent clearly and repeatedly, since silence or compliance can be legally reinterpreted as permission after the fact by courts applying hindsight analysis. Number 19. Know that reasonable suspicion must be articulable. Officers must explain specific facts, creating reasonable belief that criminal activity occurred, not mere hunches or generalized suspicion. This requirement stems from Terry v. Ohio, establishing standards for investigative stops beyond random encounters. Demanding articulation during detention forces officers to justify their actions immediately rather than constructing explanations later. Vague responses like "you seemed nervous" often don't meet legal thresholds when challenged in court. The standard requires more than inchoate suspicion but less than probable cause, occupying a middle ground. Courts evaluate whether facts known to officers at the stop's inception would lead reasonable officers to suspect criminal activity. The verdict? This knowledge transforms detention questions from procedural formality into substantive challenges of police authority, though most officers have practiced articulating suspicion in legally acceptable terms that courts rarely second-guess. Number 18. Understand the SOS lockdown feature. Pressing the iPhone power button 5 times triggers emergency mode while simultaneously disabling biometric access and requiring passcode entry for all future unlocks. This feature originated in iOS 12 as a safety mechanism that coincidentally serves privacy protection during police encounters. The speed of activation makes it feasible even during traffic stops, though conspicuous. Button pressing might escalate situations. Android equivalents exist but vary by manufacturer, requiring device-specific research. The feature also displays medical ID information and emergency calling options on screen. Some users report accidentally triggering it in pockets, leading to embarrassing emergency calls. The verdict: this single action provides immediate Fifth Amendment protection without requiring settings navigation under stress, making it the most practical real-time defense against forced biometric unlocking that you can execute in seconds. Number 17. Recognize that warrants don't disappear when you comply. Officers claiming urgency to search without warrants often rely on suspects believing evidence will vanish, even though detained persons and seized property aren't going anywhere. The Payne case exemplifies this false urgency, since police controlled both Jeremy Payne and his phone, eliminating any exigent circumstances. Courts theoretically punish such shortcuts by suppressing evidence, but rarely do in practice. Civil liberties groups argue this manufactured urgency doctrine has eroded Fourth Amendment protections substantially. The reality is that modern phone encryption means data remains secure indefinitely once devices are in police custody, giving officers unlimited time to obtain warrants. Remote wipe concerns can be addressed by placing phones in Faraday bags that block signals. The verdict: understanding that police convenience isn't legal justification exposes the weakness in many warrantless search rationales, though courts remain reluctant to enforce these principles consistently, deferring to officer claims of necessity. Number 16. Learn about plain view. Doctrine limitations. Officers can seize evidence in plain sight without warrants, but can't manipulate objects or positions to bring items into view, creating boundaries on observation-based searches. This doctrine explains why phone placement matters, since visibility determines whether police can claim plain view justification. Case law establishes that officers can't open containers or move objects to create plain view situations. The doctrine particularly affects vehicles where windows provide visual access, but closed compartments require additional justification. Courts scrutinize whether officers had lawful vantage points when observing evidence and whether incriminating nature was immediately apparent. The doctrine doesn't authorize searches but only seizure of already visible evidence. The verdict: strategic placement exploits these limitations effectively, though officers skilled in positioning themselves to maximize visual access often work around these restrictions by carefully choosing approach angles and using flashlights. Number 15. Understand that questions aren't commands. Police phrasing searches and identification demands as questions rather than orders creates psychological compliance while legally remaining requests requiring consent. This linguistic technique exploits most people's inability to distinguish between lawful orders and voluntary requests during encounters. Training materials teach officers these psychological tactics explicitly to maximize consent-based searches. Commentary threads emphasize that "can I search your vehicle" is fundamentally different from "step out of the car," even though tone makes them sound equivalent. The distinction matters because consensual searches are legally valid, while commanded searches without justification violate rights. Officers use interrogative forms specifically because courts have held that questioning doesn't constitute coercion. The verdict: recognizing interrogative phrasing as requests rather than commands requires conscious analysis that few people manage during stressful encounters, despite its legal importance for preserving Fourth Amendment protections. Number 14. Know about passcode. Fifth Amendment protection courts protect passcodes and passwords under the Fifth Amendment because revealing them requires transmitting knowledge from your mind, qualifying as testimonial communication that can't be compelled. This protection creates the fundamental distinction between biometric and password security, since typing characters necessarily involves cognitive content. The doctrine stems from cases establishing that communicating the contents of your mind receives constitutional protection even when incriminating. Encryption advocates celebrate this as one of the few robust digital privacy protections remaining. Some courts have created exceptions when prosecution can prove they already know passwords exist, making them foregone conclusions, though this remains contested. The protection applies regardless of password complexity or whether officers suspect incriminating content. The verdict: this principle makes passcode-only security the gold standard for Fifth Amendment protection, though enforcement varies by circuit and officers often don't respect it in practice, sometimes using coercive tactics anyway. Number 13. Understand booking fingerprint. Exceptions. Fingerprints taken during booking are legally compellable as identification procedures rather than testimonial communication, explaining why courts draw distinctions between booking and investigation contexts. This precedent formed the basis for Judge Tillman's reasoning that forced biometric phone unlocking resembles booking fingerprints. Critics argue this analogy fails since fingerprints identify individuals, while phone access reveals comprehensive life details. The exception reflects broader Supreme Court doctrine that physical characteristics can be compelled for identification purposes. Historical context shows fingerprinting became standard practice for identifying arrestees and matching them to criminal records. Courts view this as administrative necessity rather than evidence gathering for specific cases. The verdict: this exception helps explain judicial reasoning in biometric cases, even though the comparison between identification and full digital access seems legally questionable given the vastly different privacy implications involved. Number 12. Learn that traffic violations don't authorize phone searches. Minor traffic infractions create justification for stops, but don't establish probable cause for searching phones or vehicles without additional criminal indicators. Jeremy Payne's window tint violation illustrates how pretextual stops can escalate into major privacy invasions. Fourth Amendment protections theoretically require nexus between the violation and the search scope. Commentary emphasizes that officers routinely exceed these boundaries by treating any stop as opportunity for broader investigation. The Supreme Court in Arizona v. Gant limited vehicle searches incident to arrest, requiring nexus to the offense, or reasonable belief evidence will be found. Traffic violations rarely provide justification for phone searches since they don't involve digital evidence. The verdict: knowing these limits helps identify rights violations, though the gap between theoretical protections and practical enforcement remains substantial, with officers often searching first and justifying later. Number 11. Recognize pattern lock. Vulnerabilities. Swipe patterns and gesture-based unlocking mechanisms occupy uncertain legal territory between biometric and passcode protection, with limited case law addressing their Fifth Amendment status. Number 21. Understand warrant requirements for blood. Draws. The Supreme Court's 2016 ruling requires warrants for blood draws, absent consent or exigent circumstance. These methods require some cognitive input to execute the pattern, but might be observable through shoulder surfing or smudging. Security researchers note pattern locks offer weaker protection than alphanumeric passwords, both technically and legally. Courts haven't definitively ruled whether compelling pattern reproduction constitutes testimonial communication. The hybrid nature makes them unpredictable in legal challenges since they involve both knowledge and physical movement. Fingerprint oils can reveal patterns on screens, making them vulnerable to forensic analysis. The verdict: pattern locks provide minimal privacy protection and should be avoided in favor of strong passcodes given their ambiguous legal status and technical weaknesses that make them easily compromised. Number 10. Understand exigent circumstances. Exceptions. Emergency situations threatening evidence destruction, public safety, or fleeing suspects allow warrantless searches, creating exceptions to Fourth Amendment protections. Police frequently claim exigency to justify warrantless actions even when circumstances don't genuinely require immediate action. Courts theoretically scrutinize these claims carefully, but often defer to officer judgment. The doctrine particularly affects phone searches when officers claim data might be remotely wiped. Genuine exigencies like active shooters or bombs justify immediate action, but routine investigations rarely present such urgency. Courts evaluate whether officers reasonably believed exigency existed based on information available at the time. The verdict: understanding exigency standards helps evaluate whether police claims legitimately justify warrantless intrusion. Though officers' ability to retroactively construct exigency narratives undermines these protections significantly. Number 9. Know how to invoke Fifth Amendment rights. Explicitly saying, "I invoke my Fifth Amendment right to remain silent," or "I invoke my right against self-incrimination," provides clear legal protection while mere silence doesn't trigger constitutional safeguards. Supreme Court precedent requires explicit invocation using recognizable constitutional language rather than ambiguous statements. Legal forums stress that phrases like "I don't want to talk" don't reliably trigger protections. The requirement particularly matters during non-custodial questioning, where Miranda warnings don't apply. Courts have held that invocation must be unambiguous and unequivocal to be effective. Once properly invoked, officers must cease interrogation, though they can resume if you reinitiate conversation. The verdict: memorizing exact invocation language transforms theoretical rights into practical protections, though the requirement that citizens know precise legal formulas seems designed to trap the uninformed who lack legal training. Number 8. Learn about search warrant validity requirements. Valid warrants must specify particular places to be searched and items sought, preventing general exploratory searches and creating limits on scope. Officers executing warrants can only search areas where specified items could reasonably be located. Warrants require probable cause affidavits and judicial review before execution. Commentary notes that warrant particularity requirements theoretically constrain police but often contain broad language enabling extensive searches. The Fourth Amendment's particularity requirement prevents general warrants that authorize fishing expeditions. Courts can suppress evidence found outside warrant scope unless officers can justify expansion. The verdict: understanding warrant requirements enables evaluation of whether police are exceeding authorized scope, though most civilians lack expertise to assess validity in real time during execution. Number 7. Recognize that data doesn't disappear. Digital evidence on seized phones remains accessible indefinitely once devices are in police custody, eliminating legitimate justifications for forcing immediate warrantless access. Modern phones employ encryption requiring passcodes, but police can secure devices while obtaining warrants without evidence loss. The Payne case illustrates how convenience rather than necessity drives warrantless phone searches. Technology companies and privacy advocates argue this permanence requires treating phone searches like any other warranted search. Remote wipe capabilities can be defeated by airplane mode or signal blocking. Data remains on devices even when inaccessible, giving police unlimited time. The verdict: this reality exposes the weakness in urgency-based justifications for warrantless phone access, though courts continue accepting them despite logical inconsistency with digital evidence permanence. Number 6. Understand facial recognition. Compellability courts classify facial recognition unlocking as non-testimonial, since officers can simply hold phones to faces without requiring cognitive participation or knowledge revelation. This treatment mirrors fingerprint doctrine, where physical characteristics can be compelled for identification purposes. The classification seems inconsistent, given that facial recognition provides full digital access rather than mere identification. Privacy advocates argue faces shouldn't be treated as passwords that police can forcibly use. The technology works passively without requiring user cooperation beyond physical presence. Some jurisdictions have begun questioning whether this doctrine adequately protects privacy given modern technology. The verdict: facial recognition provides essentially no Fifth Amendment protection against forced unlocking, making it the weakest security option despite its convenience for daily use. Number 5. Ask, "Am I being detained?" to clarify your status. This question forces officers to articulate whether you're free to leave or being held for investigation, establishing your legal status and available rights. Detention requires reasonable suspicion of criminal activity, while consensual encounters allow you to leave anytime. Officers often evade direct answers using phrases like, "I just have a few questions," that maintain ambiguity. Legal advice consistently emphasizes repeating this question until receiving clear answers. The question transforms unclear encounters into defined legal situations. Courts evaluate whether reasonable people would feel free to leave based on totality of circumstances. The verdict: this single question transforms unclear encounters into defined legal situations, enabling appropriate rights assertion. Though officers trained to avoid direct answers can frustrate this strategy with evasive responses. Number 4. Never consent to searches. Under any circumstances, verbally refusing consent to all searches forces police to obtain warrants or establish probable cause, preserving Fourth Amendment protections and creating suppression opportunities for illegal searches. Consent searches represent law enforcement's easiest method for bypassing constitutional requirements. Courts interpret any ambiguous response as potential consent, making explicit refusal essential. Innocent people struggle with non-consent because it seems suspicious, but cooperation only risks self-incrimination. Officers may pressure or intimidate, but cannot search without legal justification. Refusal cannot be used as evidence of guilt in court. The verdict: this single refusal represents the most powerful tool for asserting Fourth Amendment rights, despite social pressure and officer manipulation, making it psychologically difficult to refuse authority figures. Number 3. Use alphanumeric passcodes instead of biometrics. Strong passwords combining letters, numbers, and symbols provide robust Fifth Amendment protection, since courts can't compel revelation of knowledge from your mind. This security method forces police to obtain warrants and prevents physical compulsion tactics used with biometrics. Password-only security closes the non-testimonial loophole entirely by ensuring phone access requires testimonial communication. The inconvenience of typing passwords represents minor cost for substantial constitutional protection. Longer, complex passwords provide both technical security and legal protection. The method makes forced access impossible without your cooperation. The verdict: this single security decision transforms your phone from vulnerable to forced access into constitutionally protected digital space, making it the most important privacy choice you can make. Number 2. Ask if police have a search warrant. Demanding warrant production immediately establishes whether police have judicial authorization or are attempting consent-based searches, fundamentally altering encounter dynamics. Officers with warrants will produce them immediately, while those without typically retreat or attempt psychological pressure. This question signals legal awareness that often deters rights violations. Commentary universally identifies warrant demands as crucial first responses to search requests. The question puts officers on notice that you know your rights. Valid warrants must be produced and you can examine them. The verdict: this question cuts through police rhetoric instantly by requiring them to demonstrate actual legal authority rather than manufactured urgency or implied authority. Number 1. Immediately request a lawyer and invoke your Fifth Amendment rights. Saying, "I want a lawyer" and "I invoke my Fifth Amendment right to remain silent" stops all questioning and provides maximum legal protection during any police encounter. These combined invocations trigger both Sixth Amendment right to counsel and Fifth Amendment protection against self-incrimination. Police must cease interrogation once you invoke, though they may continue gathering other evidence. Every legal expert and attorney emphasizes these as the most important. Words you can speak to police. The combination prevents the single greatest source of criminal convictions, which is defendants talking themselves into charges. Research shows that innocent people incriminate themselves regularly by trying to explain or cooperate without without counsel. Studies demonstrate that even exculpatory statements get twisted during prosecution, and that attempting to talk your way out of situations almost never works. Officers are trained interrogators, skilled at extracting admissions through psychological techniques that civilians cannot effectively counter. The invocation must be clear and unambiguous to be legally effective. The verdict. These two sentences represent your most powerful legal protection and should be the first and last things you say during any police encounter, regardless of guilt or innocence, trumping every other strategy because they activate the constitutional protections that preserve all your other rights while preventing the self-inflicted damage that destroys most criminal defenses before they begin, making this the single most important advice for any police encounter.